gang affiliation, that there were, and I note that there was a warrant taken out initially in this case about gang affiliation, and that he referenced more to the present business at hand. No, it's not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record, is there any statutory minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount? And it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it. And if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would be
you can't
no.
deny that injustice.
And that I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum. Are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no, and then just reread the intent charge, and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Young.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice on the record, being that this is equity jurisdiction?
Anything else?
No, I need an answer, because being that I told you that your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute in contempt of justice, I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice? Are you recontracting?
Are you done, Ms. Young? Are you done?
No, I'm not. Are you recontracting the trust?
You remember what I told you at the outset of this trial, which is that if we started getting into it, you started interrupting me. All right, Ms. Young, I'm going to find you in contempt of court. And I'm immediately imposing a 20-day sentence, no matter what happens as a result of this trial. And I'm directing you not to interrupt me any further, all right?
You asked me a question, but you didn't answer it.
I'm finding you in contempt a second time, Ms. Young. That is an additional 20-day sentence I'm imposing.
You can do as you please, because at the end of the day, you have no jurisdiction. You are in contempt of justice,
Please, if you could
and you cannot refuse.
Ms. Young from the courtroom.
Come on, yeah. You'll be hearing my fee schedule. Let me put this up.
I got that.
And you know you're in contempt of justice. It's okay. You'll be hearing my fee schedule.
We're back on the record. I've been informed by Lieutenant Lattimore that the jury has reached a verdict, and Ms. Young is now present back in court. And Ms. Young, I will remind and direct you once again that there are not to be any verbal outbursts, and I'll allow you to perfect the record at the appropriate time, but that is only going to be when I call on you. So with that, we can bring in the jury. Thank you. All judges are present, Young. Thank you, Lieutenant Lattimore. Please be seated, everyone. Members of the jury, I've been informed that y'all have been able to reach a verdict. And if that is the case, it appears that juror number 8 is our foreperson. All right, if you could hand that verdict form to the lieutenant so that I can take a look and make sure it's been completed. All right, and you can hand that back to our foreperson. And sir, if you could now publish the verdict in open court by reading it, you can remain seated and read it into the record.
Count one, possession of a Schedule I controlled substance with the intent to distribute. We find the defendant guilty. As to count two, possession of a Schedule I controlled substance. We find the defendant guilty. As to count three, crossing guard lines. We, the jury, find the defendant guilty. As to count four, possession of a Schedule II controlled substance with intent to distribute. We, the jury, find the defendant guilty. As to count five, possession of a Schedule II controlled substance. We, the jury, find the defendant guilty. As to count six, crossing guard lines. We, the jury, find the defendant guilty. As to count seven, possession of a Schedule IV controlled substance with intent to distribute. We, the jury, find the defendant guilty. As to count eight, possession of a Schedule IV controlled substance. We, the jury, find the defendant guilty. As to count nine, crossing guard lines. We, the jury, find the defendant guilty. As to count 10, violation of oath by a public officer. We, the jury, find the defendant guilty.
And that has been signed, filled in, and dated by you.
Right.
All right. If you could hand that verdict form back to the deputy so that the state may review it as well as the defendant.
Oh, I've seen this.
All right. Starting with the state, is there any objection to the form of the verdict? And is there any reason this jury cannot be excused?
No objection, Your Honor.
All right. And over to Ms. Young. Any objection to the form of the verdict, and is there any reason this jury cannot be excused?
There's an object.
All
You're
right.
still in contempt of justice, but that's it.
Back on the record for sentencing. I'll begin with the state to present any evidence in aggravation. Let's also start with your recommendation as well.
Your Honor, as the court is aware, the defendant, or the court may not be aware, but the defendant does not have a prior record. However, the state's recommendation in this case is not only based on the evidence in this case, but also based upon the fact that the defendant has not accepted responsibility for her actions and in the situation that she caused at the jail, and the fact that her actions potentially put inmates and other people at risk. For that reason, Your Honor, the state recommends the following sentence. With regards to counts 1 and 2, we believe count 2 would merge with count 1. State's recommendations on counts 1 and 2 are 15 years to serve 10. State's recommendation on count 3 is 5 years to serve, concurrent with counts 1 and 2. Regarding counts 4 and 5, again, the possession in count 5 would merge with count 4. State's recommendation is 15 to serve 10. The recommendation for count 6 is 5 years to serve, to run concurrent with counts 4 and 5. Counts 7 and 8, Your Honor, the state would recommend 15 to serve 10, with count 8 merging into count 7. And on count 9, 5 years to serve, to run concurrent. And then for the violation of oath, state would recommend 5 years to serve to run.
In terms of evidence and aggravation, Ms. Boykin, at a prior hearing, you didn't have the case at the time, but it was Mr. Herzog who made representations that this case involved gang affiliation. that there were, and I note that there was a warrant taken out initially in this case about gang affiliation, and that he referenced other evidence showing that she was distributing directly to inmates. And so is that something the state is prepared to introduce in aggravation here today?
Your Honor, the state does have information related to that. We do not have the witness here to testify regarding those matters. Should the court hold a scheduling hearing or a hearing at a later date, we can have that witness available given this time of day.
All right. Well, not hearing a request to continue sentencing and the evidence not.
Would request for the court to continue sentencing to hear from that witness.
And the state's recommendation, though, would remain the same after presenting this aggravating evidence.
It would, Your Honor.
All right. And just by, wouldn't consider it unless we did hear that evidence, but by way of proffer to complete the record, what would be your proffer, what that witness would testify to?
Your Honor, the witness, Raylene Bruce, would testify that she too worked at the Fulton County Sheriff's Department. She assisted Investigator Green with obtaining the defendant's cell phone. A subsequent dump of that cell phone did show that the defendant was communicating not only with inmates, but with other individuals to sell items, to sell drugs within the jail. There are also some Instagram postings for the defendant. And there's also photos of her gang tattoos that were taken at the Fulton County Jail.
All right. Ms. Young, at this point, should you choose to do so, this is an opportunity for you to tell me anything about yourself, your character, your background, anything that you think I should consider in mitigation, meaning why you deserve a lesser sentence and whatever sentence you recommend. And so to that end, the floor is yours.
So as I said earlier, on the record, we are in equity jurisdiction, correct? You have no answer?
I'll have an answer for you shortly, Ms. Young.
Okay. So the failure or refusal to proceed in equity under exclusive jurisdiction will constitute in contempt of justice. As I said earlier, I was seeking administrative remedy, awaiting your communications to be delivered to correct parties. You are in contempt of justice by not allowing the surety, the implied surety, to produce this receipt of payment. So with that being said, my fee schedule will be on the record publicly soon, as soon as I can. But again, I have a 4-year-old son. Like I said, there was a lot of miscommunication. You have been in contact with my mother and my father without my knowledge, and they have miscommunicated the time that I was supposed to be back. I told them the situation. And as I was getting lunch and headed back to the courthouse where your officers intercepted, that's all that was being said. So, and I was not read my Miranda rights as well, just putting that on the record as well. And also to clarify again, the respondent had a duty to all complaints and questions because of the legal special relationship of the parties by not responding to the respondent via the indictment, the true bill that was originally sent to the respondent, is in breach of trust because of the infant estate and duty of care associated therewith and thereto in an express trust. The court and its officials, the prosecutor or the plaintiff, being that the state cannot represent itself, obviously, our legal title holder of not only the express trust, but also the constructive trust, as now have been placed on the record. I share the same or similar name again as the named defendant in their case number 23 SC 192047. However, for clarification, I am not acting in the capacity as the named defendant. I am the beneficiary and equitable title holder. None of this information is foreign to the court. This matter must proceed in equity, and failure or refusal to proceed in equity under exclusive jurisdiction, which you said we are in, will constitute contempt of justice. I am appearing, especially and not generally. I'm trying to let you know that this case has been settled. And until that notice reaches you, until I'm able to go do what I need to do to make sure your notice reaches you, I'm here. So again, I would like to seek administrative remedy, awaiting your communications to be delivered to the
Ms. Young, you raised and said that you have a 4-year-old.
I do.
Who is caring for your 4-year-old at this moment?
I have no idea right now because his daycare closed at 6:00 p.m.
And so you've left your 4-year-old in the care of a daycare and made no plans.
My mother, I have no way to contact. I have no way to do anything because you intercepted before I could do what I was supposed to do.
All right. And so your mother has the ability to care for your 4-year-old?
I have no idea because I've not been able to speak with anyone. You are holding me against my will right now. So no, I have not spoken to anyone.
And what daycare is your son at?
Why?
Well, the answer would be because we want to make sure he's taken care of. And we actually have some regard for him, unlike what you've shown here today.
How have I shown no regard for my son?
Do you have anything further to present, Ms. Young?
Other than you're in contempt of justice? No.
All right.
You can proceed to doing
Okay, with that, I will announce the sentence in this case. I'll say I don't believe deferring or continuing this to a later date is needed because I'm willing, at a minimum, to accept the state's recommendation based on what's already been presented. I don't think aggravating evidence is needed here. I'll just start off by saying I don't think I've ever seen a more ineffective presentation at a sentencing hearing. Ms. Young, you've taken no responsibility not only for these acts, but you've completely thumbed your nose at this process and at the law that you swore to uphold. You've lied to me. You've embarrassed yourself and the department you used to work for.
Aww.
And you've contributed to the crisis we've had at this jail that we've had to experience for years. You're the cause of the danger that everyone who works there and has to be detained there has to experience. So I'm not going to belabor the point, but the sentence in this case will be 40 years to serve 15 years with the balance on probation. We'll stack the charges.